everyone. It's so great to see you all, and I know more will be joining, and then we'll have folks watching the video afterwards. So good morning. Today is April 28th, 2022, and welcome to the New Possibilities Hour. We have a special guest this morning, Jon Teller. And before we get into talking about Jon, though, and his food bank, let's find out the numbers and where we stand from the donations of which we know so far. Jeff?
Thank you, Jean. I'm so happy to announce that our audiences have been so generous in contributing to food banks in honor of our great speakers. Since Natalie founded the Will Work for Food Project, and since we've been at this for a little over 2 years now, since the spring of 2020, our audiences have contributed a stunning total of $271,711.10. Every dime counts, every penny helps to provide food for people in need. Thank you so much to our wonderful presenters, Jon Teller, including you as of right now. Thank you so much to our generous audiences. Back to you, Jean.
Thanks so much, Jeff, and thank you all. It's just fantastic. And so the thanks today go to Jon Teller. He is a lawyer who is a personal injury lawyer who has accolades coming out of his ears, so to speak, as a phrase there. Just this last week, 4 days ago, I believe it was, maybe a week ago, on LinkedIn, for example, there was a post that he had recovered $8 million and he'd done had two trials just in the past 30 days. So the numbers are staggering on what Jon is able to get in terms of settlements for his clients. Personal injury work, accidents, things like that is his specialty. He is a partner and award-winning senior trial attorney at Wilshire Law Firm. He has helped his clients obtain 20 of the top 50 personal injury settlements in California in 2020. He was nominated for Attorney of the Year by the Consumer Attorneys of California in 2020. And in 2021, the Consumer Attorneys Association of Los Angeles nominated Jon as Trial Lawyer of the Year. He has recovered more than 80 million for his clients while he's been at the Wilshire Law Firm, and he settled a case in 2019 after winning the liability phase of a trial against a school district with 100% liability against the school district. He received the case settled for more than $28 million. Needless to say, Jon is an attorney to watch. He, as various organizations have said, and I was teasing earlier, but I mean it most sincerely, 20, 30 years from now, when we're all old and gray, Jon will be the attorney who will be called in to give war stories of all of his great victories, but his settlements too, his mediations. And I think as mediators, as attorneys, we can all learn, what makes a plaintiff lawyer tick when they're in mediation, when they're considering settling cases, etc. And this is from a lawyer who's not afraid to try a case. So I give you Jon Teller. His charity or his food bank is Jewish Family Services of LA. Natalie will put that in the chat. And Jon, thank you so much for being here. It's a pleasure. The floor is yours.
Thank you so much for having me. And all my successes really come from people like Jean and those that have taught me. I actually used to work for Jean at Murchison Company. I used to be on the defense side. So everything I learned is from her and that firm and all the attorneys that I continue to learn from. The food organization, the food bank that we are sponsoring, Jewish Family Services, an incredible organization. I'm sure most of you have heard of it. They really go out of their way to work with the individuals that need food, and they go out of their way to make sure that they get what they need. Sometimes it's a little bit complicated, or people live in funky areas of town. And I know they're one organization that really does everything they possibly can to make those in need and help out. So if you can all donate, it's absolutely going to a great cause. And you can check out their website and read, they can obviously tell you a lot better about what they do than I do, but read about them on the website. It's really, really important what they do. There's a lot of incredible organizations out there that everybody has sponsored. They're just another one of them to add to the list. So please consider them and donate. So with all that said, I'm here to talk about mediation, which I'm very excited to talk about. I have a lot to say on the topic. I could probably talk about mediation for, a full day, 8 hours and then some. So I want to start off by telling you a little bit about what I do before mediation, because it really starts well before we actually get there to mediate a case correctly. A lot of attorneys out there, both really on the plaintiff side and the defense side, really wait way too late to be effective in the mediation. They wait till like a week before, sometimes even a couple of days before, and that is a real killer for mediation. I worked on the defense side, for 5 years, and then now I've been working on the plaintiff side, and I've seen a successful mediation compared to an unsuccessful mediation. And a lot of the time, that's really all about the preparation prior to mediation. So what does that mean? The first thing I always do well before I even agree to a mediation is, do you know what the goals are of the mediation? A lot of times for most plaintiffs' attorneys, they think the goal is to settle at mediation. Not always the case. You don't need a mediation to be set up to settle the case. Although I know from the mediator's perspective, that's like the most important thing. Mediators are usually, want to go into a mediation to settle the case. But, sometimes either on the plaintiff side or the defense side, the goal maybe not be to actually settle the case. Sometimes you really are there to educate people. From the plaintiff side, sometimes if you have a tough client, you're actually there maybe to educate your client. Hopefully that happens less often than more often. Hopefully you're able to talk about the case and educate your client on your own. But sometimes you do need a judge or a mediator to help you do that. Similarly, sometimes we are there to educate the insurance adjuster or the senior partner on the case from the defense side that has only been getting updates from their nice, associate who's taken a lot of the depositions, and the senior defense partner who's going to try the case doesn't really know so much about the plaintiff or as much as you'd like them to. And similarly, the adjuster, sometimes you really need to help educate the adjuster. But, for the most part, you are there to try and settle the case. So what does that mean? So you need to know what your goals are, again, prior to the mediation. That means talking to your client. Again, on the plaintiff side, I usually have a meeting with my client, usually twice prior to a mediation. One hopefully like 30 days before, and one probably closer to like 2 or 3 days before the mediation. And at that time, I discuss what are their goals. Do they want to for sure settle the case? Like some people are very adamant, like this case has been dragging on for 2-3 years. I just want it done. I want it settled. Okay, so now you want to settle the case. Is there a certain amount of money you want? It's shocking to hear. I hear stories of other people, or again, when I was on the defense side, sometimes I've heard stories that the plaintiff and the plaintiff's client have not actually discussed numbers until they're at the mediation. And then they're trying to figure out from their client, well, how much do they want? And then all of a sudden their client is saying, well, how much are the costs and how much are the fees that I owe? And then all of a sudden you're like, almost having a mediation with your client against your client. And the mediator is like, hello, I want a number from you to go back to the other room. Those conversations should happen well before you get to the day of mediation. I don't know why people are afraid of those conversations. It's your client at the end of the day. Don't be afraid of your own client and having real life conversations about the case and what the case is worth. All the liability issues, know the liability issues. If it's a big liability to dispute case, have that conversation with your client beforehand, of course. So those are things that really should be done beforehand. Another big piece of advice that I have for definitely plaintiffs' attorneys out there, and even honestly the defense as well. If you want to go into a mediation and you want to settle the case and you want to make sure you get the value you get or you want to get, do depositions prior to mediation, and not just the plaintiff's deposition. I know so many plaintiff firms out there that do not proactively litigate their cases. They just wait around and allow the defense to take their client's depo, and then that's it. And then hopefully I'll go to mediation right away. Yeah, that is a good strategy in some regards, but most of the time, I promise you, if you spend the $2,000 or the $3,000, I know depositions are costing more and more every day, but if you spend the $2,000 on a good deposition of someone, that ultimately, as you know, the defense will then report it to the adjuster, and that might change the conversation from the defense and insurance adjuster's perspective in terms of the value of the case. What I mean by that is, if you are representing a plaintiff who has, let's say, a spine surgery, and you feel like you can settle that case to $500,000, $600,000. If you take the deposition, let's say, of the treating doctor, the treating surgeon, and you spend a little bit of money, sometimes it's worth spending $2,000 to $5,000 to get, a value of $100,000 or even $500,000 more on your case. To tell the insurance company that you're proactively litigating a case, it not only shows the insurance company, the defense attorney, but even the mediator, I think a lot of the times, that you are really invested in the case and you believe in the case. If you don't take depositions, you're showing, I think, a side of weakness. And I think that applies equally sometimes for the defense, is sometimes by showing the plaintiff's firm that, hey, I'm going to go out there and take depositions, which ultimately make the case cost a little bit more for the plaintiff as well. You're going to show the plaintiff side, hey, you know what, we're going to actively litigate this case because we really don't believe in the case and we don't believe in the value that you are suggesting. So we're going to take depositions and show you that we're prepared for trial. I think that's a big pre-mediation proactive way to litigate cases to help you for mediation that people don't consider a lot of the times. Next, things to do before mediating a case. Mediation briefs. This, everybody probably says it, but for some reason, nobody gets it done. So I'll just say it. Get your mediation briefs into the mediator and the defense side, hopefully 30 days before mediation, and send mediation briefs to the other side. The idea, especially if you're on the plaintiff side, to not send your mediation brief to the defense and the adjuster is absolutely just bonkers to me. I would say maybe 1% of the time should you not send the defense and the insurance adjuster your mediation brief. And that is like a very unique set of facts on a very unique case. 99% of the time, I always send my mediation brief to the defense. And I always try to send the mediation brief at least 30 days before mediation. 30 days. If you're sending your mediation brief 5 days before mediation, you've already not settling the case for as much as you hoped you were going to settle it for. Why is that? Well, as a former defense attorney and someone that is friends still with a lot of defense attorneys and adjusters, I know that the conversations about how much settlement authority they're bringing to the mediation happens at least 5 days before a mediation, most of the time 10, 15, 2 weeks before a mediation. So I would strongly encourage a plaintiff's attorney to send their mediation briefs as soon as possible. 30 days before. My team at my firm know that if I don't send it 30 days before, I'm kind of upset at myself. It happens. We all get really busy, of course, but we try our best to get those briefs out. Another reason why, not only is it important that they know your position and know how much you're demanding, but also the medical bills. We all know, although a lot of us don't want to admit it, a lot of insurance companies base their evaluation on the value of the case based on how much the medical bills are. That's at least definitely something that's considered. You can't say it's not considered at all. It's for sure considered. And oftentimes the numbers that you have, meaning the plaintiff has, and the defense has, is a different number. And I can't speak for every state, but I can speak for California. That's oftentimes because the Howell number is a dispute, or just people don't have all the bills. It's really important to get those over to the defense and the insurance company to make sure everybody's on the same page as to the number of the medical expenses. I've seen, again, more so when I was a defense attorney, that we get to mediation and then defense counsel and the plaintiff's counsel have like $100,000 disparity in what the past medical bills number is. That literally should never happen. That changes the whole dynamic of the mediation. Don't be afraid to make a phone call or an email to defense counsel, or vice versa. Defense counsel can make a call and send an email to plaintiff's counsel and say, hey guys, the past medical expense number I have is $253,000. What's the number you have? And just work it out before mediation. I don't see why that has to be a mystery going into the mediation. So that's really, really important. The next really important thing I always do at the mediation. Now let's go to the mediation itself a little bit. And I'm going to jump around a little bit. I'm going to share my screen. This is probably the only time I'm going to share my screen. For some reason, again, when I speak to fellow attorneys that have like referred me cases and whatnot, don't have something like this. Can everybody see my screen? Can someone give me a thumbs up? It's an Excel sheet. I don't understand how someone does not have an Excel sheet set up, or at least a pad and a paper, and you're very good and to be very good at math. And it's super simple what I do. All it is you have a demand column here, an offer column here. What is your last demand? What is your offer? And then have the average. Everyone needs to know what the middle number is. All right. That's just, I mean, I think that's mediation 101. I think a lot of people know that, but it is shocking. Sometimes I see people not knowing what the middle number is. You know, you'll obviously always have people, oh, I don't care about what the middle number is. I'm not looking to settle the case for the middle number. That's fine. You might not want to settle the case for the middle number, but you damn well better be sure you know what that middle number is. And I'll get to that in a second why. Next is I separately have a demands and offer column. So then let's say my next demand is 950,000. I put it there. Next offer hopefully is a lot higher. Put it there, and I'm keeping track. And then you just know how much the average is of how much the demands and offers are going up. So it's really important to keep track of that. So look, you see how the middle number changes. 50,000 goes up here, the middle number changes. So it's really important to know what that middle number is. I can't stress that enough. It's shocking that when I ask people again about cases like, all right, well, what was the last offer? What was the last demand? What's the middle number? They don't know. Why do you want to know what the middle number is? All right, there's a million reasons why you would want to know. Obviously, the first reason is because that really sets the bar as to what the case might settle for, at least. Maybe no one wants that middle number, but if you keep going move after move after move, and that middle number is staying roughly the same, then that speaks volumes as to what people are thinking subconsciously in the other room. The next most important thing, and this is more of a big plaintiff's rule of thumb that I think a lot of plaintiffs' attorneys don't realize, and that I am paying a lot of particular attention to, and I'm even taking statistics on at this point, is that let's say the case does not settle at mediation. Case does not settle. You want to know what that middle number is, because you better believe that the insurance company is reporting that, or the defense counsel is reporting that, as to what the middle number was at mediation. When you are a plaintiff's attorney and you're trying to get the insurance company to increase the authority they have on a case and increase their reserves, I think it's really important to make sure that that middle number is well above the number that you want to settle for, and sometimes well above the insurance policy limits. So there are so many scenarios why you're going to mediation and when you're going to mediation, but let me give you a typical example of it's like an open policy case, or the plaintiff's attorney wants to say it's an open policy case, and you want to show the insurance company that you really mean it. So number one, obviously you need to have a settlement demand before the case even goes to mediation, hopefully a lot longer before, and you've done the proper communications and exchanged all the information about why the case was worth the policy limits when you made the demand. That's a whole separate seminar on settlement demands and opening up a policy. But let's say you feel that you're in a good spot, that it's $100,000 policy limit, they didn't pay it before, and you really want to feel that you're good on that. You want to make sure that obviously your demand is going to be well above the policy limits, but you also want to make sure your middle number is always above the policy limits. That is key. Don't think, oh, well, your last demand is above the policy limits and you're good. I think strategically, subconsciously, for reporting purposes, you want to keep your middle number above the insurance policy limits. So if the insurance policy limits is $500,000, or if the insurance policy limits is $1 million, and you really do believe you have that case that's worth well north of $1 million, or well north of $250,000, or well north of $500,000, that middle number should be above the policy limits at all times. That's a general piece of advice that I've received from other people that are way smarter than me, and I think it's helped me, and it's proven success as to why I've settled so many cases well above the insurance policy limits. Obviously, for those that are not out there, you need to know what the insurance policy limits are going into the mediation. That's just a given, I hope. There's a lot of things that I'm taking for granted, but for those out there that, are wondering, make sure you know what the insurance policy limits, and make sure you've gotten confirmation of that. And I've heard so many horrible stories where there's an umbrella policy and nobody knows about it, and then it only comes out later and the umbrella carrier is not there. If you're agreeing to a mediation and there's an umbrella policy and the case is worth more than the primary layer, you better make sure that the umbrella policy carrier is there. Otherwise, everybody is wasting their time, and then everybody gets frustrated. Oh, why wasn't that adjuster there? Oh, because nobody told them to be there or whatnot. So make sure everybody is communicating with that umbrella carrier. All right. Other really important things from the plaintiff side. Sorry, I'm speaking a lot from the plaintiff side, but that is kind of what I know best, at least of. But 998s before mediation. This is also a classic, I think, mistake that people make. If you sent a 998 before a mediation, like hopefully 60 days before a mediation at least, or 90, 120 days, and defense counsel then calls you up, which they will inevitably do, and ask you, hey, will you extend that until the mediation date? The answer should always be no. I don't know why any plaintiff's attorney ever would agree to extend the 998 acceptance, which is normally 30 days or 30 plus 5 days if mailing, to the mediation date. Makes absolutely no sense. Mediation, the concept of mediation means you're there to negotiate. So that means inevitably, if you're the plaintiff, you're going to have to go down in your number. So if you sent a 998 for $1 million and you agree to extend it till the mediation date, that just implies that you're telling everybody, okay, you're not expecting to get $1 million on the case. I don't understand the logic ever, quite honestly, of extending a 998 offer. There are some times, let's say a surgery happened and the surgery bills are not in, or the surgery report's not in. So you say, okay, or there's a deposition of the plaintiff coming up, like, a couple days before the 998 expires, and you want to make sure the defense has reported that to the insurance company. Fine, maybe that's when you want to extend a 998, but otherwise I would never do it. Hopefully most people are from California here and know what I mean by a 998. But let's just say any demand, quite frankly. If you make a demand prior to mediation, that I would always, first of all, make a demand well before, 30 days before mediation. Again, you want to get the mediation brief out. You want to get your demands out well before mediation. Some people that go into a mediation, I've heard cases where have been referred to me where there's a mediation set up and then they tell me no settlement offers and no demands have been made at all. It's like, what? Why are you going to mediation for the first time to make your first demand? That is crazy bonkers to me. Again, you want everybody to know what your settlement demand is well before the mediation so that the insurance company and the defendant and their clients can all speak about it well before the mediation. So please don't go to a mediation where no offers and demands have been communicated. Sometimes no offers. That's not horrible. It's not ideal. I usually try to convince the defense attorney to make a little bit of an offer beforehand, but definitely make your demand well before mediation. Quite honestly, from my perspective, I think it's best is the plaintiff should make their demand in their mediation brief. There's so many times I've seen mediation briefs, again, from when I was on the defense side, or even now when people have referred me cases, and there's no demand in the mediation brief. Mediation, most of the time, or a lot of the times, is a half day. Yeah, sometimes it's full day. On those half dayers, though, you don't have a lot of time. So you, as the plaintiff's attorney, want the mediator to start off in the defense room. You don't want to waste so much time spending with your client and getting a demand out. Get the demand in the mediation brief, again, 30 days out, so the mediator knows what your demand is, and the defense and the insurance company knows what your demand is, so that at first they need to go to the insurance company's room because the ball will be in their court to make the next move, which would be the offer. Why let them spend so much time in your room? Yeah, maybe you want them to come to your room and meet your client first, and you want to talk maybe, again, a huge liability dispute or very weird law, and you need to talk about it. Okay, fine. But again, 9 out of 10 times, I always want the mediator in the defense insurance company room first to get the ball rolling. We're there to talk about numbers. Let me repeat that. We're there to talk about numbers. Again, 9 out of 10 times, you're there to get the numbers for your client. Plaintiff's counsel, you're there to settle the case. You're not there to have a dispute about what the law is and what needs to be done in terms of a discovery dispute. You want to have a discovery referee? Go get a discovery referee. You don't need your mediator to play discovery referee. It's crazy to me that if you're like 3 hours into a mediation and you've had only one settlement demand and one offer out on the table because you're spending so much time arguing about the law and the facts of the case. Don't do it. In fact, I usually am super, super respectful. I think I have a really good relationship with every single mediator, quite honestly. The one time I get a little bit aggressive is that if the defense is really pushing to get into the weeds on something, I will tell the mediator, and I feel like we've been talking about it too long, I will probably tell the mediator, with all due respect, we're here to talk about numbers. Here's my number. Can you please go get a number back for me? Don't waste so much time speaking about, again, getting into the weeds about the facts of the case. Yeah, you do have to talk about the facts of the case. Don't get me wrong. There are a lot of times you do have to, but pick the right time when to do it and limit your time. Literally clock yourself even. Some people get carried away because they get, all of us lawyers, most of us at least, we love to argue, we love to advocate. We get carried away in the advocacy of trying to prove our case to the mediator, instead of doing what you're supposed to be doing there, is getting numbers on the table for your client so you can get the best number out there. Speaking of which, don't leave mediation until you get the best number out there. There are times, where you want to be like, oh, the big, pound your chest and say, all right, that's it, I'm leaving. If you have that great case and you have the ability to say, you know what, I'm leaving, I'm going to trial, great, good by you. That is a great case, and that can be a whole separate conversation, another webinar we have about those types of cases and maybe the strategy about that. 99% of the time, you don't have that case, you should get the best number out there. There's so many reasons for that. It doesn't necessarily mean that you have to settle the case. But again, if you want to get more money on a file, you want the insurance company to get their highest number out there. If they had authority of $200,000 and the final offer you got on the table is $50,000, wow, did you lose that day as the plaintiff's attorney, because they have no reason to go back to their manager and get the reserves way up. However, if you get them to put their last dollar on the table, the $200,000 on the table, and you say, hey, you know what, I don't want to settle the case, that's fine. At least now going forward, the file, hopefully from the adjuster's perspective, says that they offered their final authority. Now you can say, all right, in like 30 days or whatnot, you can send a new demand, or maybe a 998, and then the adjuster is almost forced to have another roundtable with their manager, and now you have a better shot at getting the reserves up, and now maybe potentially a better chance of getting more money on the table. And again, there's a lot more to say about that. Speaking of which, plaintiff's attorneys out there, an insurance company is a huge bureaucratic company, or just a huge company, however you want to say it. Like, there's so many times where people are, oh, I can't believe they didn't bring more money, go get more money. Like, hello, they have managers, and the managers have managers, and those managers have managers. Like, if you want more money, if you're 90% of the time, you're not getting it at the mediation. Again, it goes all the way back to preparation before mediation to make sure that you get them all the materials they need to have for that roundtable that they're going to have 15 to 30 days before the mediation. Furthermore, another huge piece of advice for a lot of people, especially on the West Coast. And again, sorry, I'm jumping around, but we only have so much time and I've got a lot to cover. Mediations, if you're going to do a half-day mediation, huge secret, do it in the morning. Do it in the morning. Why? Because if you do a mediation at 2 o'clock, 99% of the time the manager is on the East Coast. And if you start trying to negotiate and getting the insurance company to make that phone call to someone else, guess what? At 5 p.m. in California, or even 4 p.m. in California, the manager is gone on the East Coast and there's no one to call and you're not getting any more money. If you're doing a half-day mediation, do it in the morning so that at 12 o'clock, they can still call their manager at 3 p.m. While we're on that topic, some people might be out there. What do you mean calling managers? What does that mean? If you don't have the adjuster call the manager at your mediation, you're just not doing the best job you can. Max out the money. Plaintiff's attorneys, get the most money on the table, and then ask them to call the manager and get more money on the table. All right. I think it's not rocket science, but people don't realize how much value that brings. Literally, it could be a difference of $5,000. I've honestly sometimes seen it go up as close to $100,000, again, depending on the case. But why not get the maximum on the table and then say, make that phone call, get me a little bit more money, get $5,000, get $10,000, get $15,000. It actually works. You know what also works? Getting the mediation costs back. That's, again, I don't know why people don't do that. I think that it makes so much sense. Mediations these days, there are really fabulous mediators out there, and their time is worth money and they deserve the money that they get. So if you have a mediator that's charging, let's say $500 or $1,000 or even $5,000, and there's obviously a huge range there. But let's say it's $5,000 per side. That's a lot of money that's going to come out of your pocket from the plaintiff side. At the end of mediation, guess what? From the insurance company's perspective, everything's a business decision at the end of the day, right? Everybody's a business. The insurance company is a business. Plaintiffs, firms is a business at the end of the day. Typically, on a contingency fee, plaintiff themselves are paying the cost. The plaintiff themselves sometimes is paying for the mediation. That's $5,000 out of your client's pocket. You want to make your client as happy as possible at the end of the day. At the end of the mediation, ask the mediator, all right, I'll only settle the case if they pay the mediation cost. Most of the time for the insurance company, that comes out of a separate pocket. There's the cost pocket that they have, and then there's the amount of money and authority they have to settle the case pocket. So again, I would say it's a very high percentage, maybe 60, 75% of the time, the insurance company will agree to get the case settled. They'll pay the $5,000 extra for the mediation costs. Again, that's another trick a lot of people don't know about, that I've just now shared with you, and now you should try it on literally every one of your cases. Let me know how that works. You'd be shocked. All right, next topic. We're running out of time. Talking to your client, mediators talking to your client. That's a huge topic. Should the mediator talk to your client? All right, I'll go really quick on that. Well, is your client good? Do you like your client? Does your client know how to speak? Does your client know how to advocate for themselves and really describe their injuries and their damages? If the answer to all of the above is yes, and hopefully you've prepared your client specifically for the deposition, but maybe also for the mediation, then the answer is yes. You want the mediator to be on your side and like your client. Again, just from a psychological perspective, if the mediator likes your client, they're going to try harder to get you more money. So I don't know why everybody's always afraid of a mediator talking to your client. Yeah, if you're one of those plaintiff's attorneys that shows up and meets your client for the first time at mediation and you have no idea what your client is going to say, then yeah, that makes sense why you don't want the mediator to talk to them. Hopefully, that's no longer going to happen after today. Talk to your client well before mediation so that they are prepared to talk to the mediator. Again, that brings huge value to the case. Next. Does your client, though, ultimately need to talk to the mediator? The answer really is no. Does your client need to be at the mediation? No. Okay. And maybe defense attorneys and insurance adjusters, if there are any out there listening, are like, what? The client doesn't need to be there? No, the client does not need to be there. I'm sorry, folks. Every time the insurance adjuster or the defense attorney says the client needs to be there, that is hogwash. Again, they have their settlement authority before the mediation. They know how much they have to offer. The client does not need to be there. However, huge caveat to that, especially in the world of Zoom mediation now, which is often the case, the client needs to be available, which is a huge difference. So that means if it comes up that the defense really wants the mediator to speak to the client for some reason or not, you have the ability to call your client and be like, all right, now you can come on for 20 minutes and talk to and meet to the mediator. Like that should be an obvious, but for some reason, it doesn't always happen. So make sure your client is always available to speak to the mediator, whether it's get on the Zoom call or have a phone call. But does your client need to be there for 4 hours or in these long ones, 8 hours in the room sitting there staring at a screen? No, they don't need to. And there's a number of reasons why I would say no. I can get in, that's again a whole long conversation, but primarily because first of all, we all know probably the first move, if not the first 5 moves, are generally very insulting. I don't want my client to get all pissed off at me that, I've represented them, that I'm this great plaintiff's attorney, and I think the case is worth $1 million, and the first offer coming in is $15,000. Oh man, can you imagine how pissed off you would be if you heard that? If you're the client that just had, a surgery, shoulder, neck, lower back, knee surgery, and you hear that. So don't that's why I don't have my clients there usually at the beginning, because I don't want them to get insulted and I don't want them to get upset at me. Later on in the day, yeah, sure, have them there and have them talk to the mediator. Again, having them available is really, really helpful. Another reason why you don't want the client to be there is because there's just a lot of times there's a lot of, warts to the case that the clients then want to sometimes advocate for themselves. And then again, you're wasting so much time. Then all of a sudden the client wants to have a whole conversation about why this issue is not an issue. And then you're, again, wasting like 30 minutes on fighting over this issue instead of getting the numbers out. I find when the client is not there, you have a lot better chance of just talking about numbers than talking about issues in the case. Sometimes, again, mediators want to talk about the clients. Oh, the defense brought this up. What do you think, Mr. Johnson? Why did X, Y, and Z happen? And then you're having a 45-minute conversation about issues instead of numbers. I want to talk about numbers at mediation, not about issues again, most of the time. And then again, hopefully again, big point out there, talking to the client obviously beforehand. You should know what your client is willing to settle for beforehand. Oh my goodness, I've heard stories. I can't even believe that this is true. I've heard so many stories where you're at mediation, you have no idea what your client's willing to settle for. Like, give me a break. Know what your client is willing to settle for before mediation, especially on the plaintiff side. I know on the defense side that it gets more and more a little bit awkward because insurance adjusters want to have control. So the insurance adjuster doesn't tell the defense attorney what the authority is, and they want to be in control of that. Okay, fine. That happens on the defense side. It is what it is. But on the plaintiff side, man, you need to know what your client is willing to settle for so that you can negotiate well. Right. And that means, folks, everybody, that means you need to know what your client is willing to accept for what's in their pocket, not what the number is in the total settlement. So, if you're talking to your client, oh, I'm trying to get $500,000 on your case, the client needs to know, what does that mean in their pocket? I'm a huge advocate of just being straightforward with clients. I don't know why people aren't. Again, that's a long conversation we can have down the road, but it hurts me. It pains me inside when attorneys are just not upfront with their clients, and then you have this huge blow-up fight with your client down the road that I've heard about, where plaintiffs are like, "What? I thought the case settled for $500,000. I want to check for $500,000," and blah 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 blah. Really, it's really important to know what your client's willing to settle for. And again, that's another reason why your client doesn't need to be at the mediation, because if you have your full client settlement authority before the mediation, you can look your mediator in the face and tell them, hey, I have full client support in terms of the authority I have to settle the case. So why does the plaintiff need to be there? If the defense attorney and the adjuster are in a separate room and they're not even going to talk to them, why does the plaintiff need to be there? Sometimes it's frustrating. I hear that the defense attorney and the insurance adjuster want to convince the mediator, oh, well, is the plaintiff hearing the numbers? Is the plaintiff hearing what the offer is and what the issues are? I can't tell you how silly that is of an argument. First of all, the plaintiff hearing that the offer is only $15,000 when they think their case is worth $500,000, that doesn't make the plaintiff want to settle for less. That makes the plaintiff want to leave the room and say bye and leave the mediation. So this whole idea of a plaintiff needing to be there to basically, have the mediator tell them that the insurance company and the defense is basically telling them, screw you, your case is worth less, makes no sense to me whatsoever, and no one will ever convince me otherwise, I think. But again, being available is great. Just some other quick pointers. First 3 moves I usually don't pay attention to. Don't be insulted by the first 3 moves. Just get the ball rolling. Get numbers out early on. Don't waste so much time. You demand $1 million. They offer you 15,000. And then all of a sudden, hell breaks loose, and then you're again started arguing about the facts. Just ignore it. Just be like, all right, they offered 15. All right, I'll go down 15. So just match them. Wow, there's so much more to talk about. It's already 8:45. I can't believe it's 8:45. We're at almost the end. I have so much more to talk about. Again, I can talk about mediation for so long, and I ran through a whole bunch of things. So I guess I think now is the best time to ask questions. The only last point I would say, and again, I know mediators generally, their goal is to settle the case. They love keeping the statistics of how many cases they settled, and that's their job at the end of the day. It's not the end of the world out there. Again, plaintiffs' attorneys who are listening, it's not the end of the day out there, world out there, if you don't settle your case at mediation. I'm not upset when the case doesn't settle at mediation. Generally, when the case doesn't settle at mediation, actually, that means sometimes you're going to get more money at the end of the day. Stay in touch with your mediator. The best mediators out there, for all the mediators are on this call, the best mediators out there are the ones that keep in touch with the attorneys after the mediation. Those that don't keep in touch, it's really, really disappointing. And quite honestly, I probably won't recommend to do another mediation with you. The best mediators if a case doesn't settle, they'll send a phone call or an email 3 days after mediation and be like, hey, what's going on? Do you want me to make a mediator's proposal, or do you have a new offer for me? It's like a quick phone call or a quick email, and that speaks volumes. And I guarantee you, I would say the success rate on that is way higher than you can imagine. That one email or 2 phone calls after the mediation successfully resolves cases more often than not. And I know plaintiffs' attorneys and defense attorneys remember that, and they're like, wow, that mediator really went above and beyond. And then we go back to those mediators more often than not. So that is critical. With that all said, I'm happy to take questions now or do whatever anybody else wants me to do. Thank you so much. It was really a pleasure. And by the way, if everybody wants to take down my email, it's Jon without an H, Jon @wilshirelawfirm.com. I'm very open to talking about cases and talking about strategy, both, again, plaintiff, and you'd be surprised, defense attorneys actually call me up as well sometimes. Jon @wilshirelawfirm.com without an H. And then my phone number, my cell number, 323-819-4172. That's 323-819-4172. Again, I'm always happy to talk about cases on either side and just, strategize. I'm a huge fan of both sides collaborating. I often even call defense attorneys to collaborate. Some of my former colleagues are brilliant, and it's really smart to not only talk to your own plaintiff's attorneys, but sometimes the other side as well to get their perspective. All right. I'm open for questions or doing whatever anybody else would like. Anybody have any questions?
That was wonderful. Wonderful. Thank you so much.
Jean, I see that you're in the car there on very important family business, and the reception is a little sketchy. It's a little hard to hear you. So if you don't mind, I'll just see whether there's some conversation to moderate here, and I hope there is. Let me join in thanking you, Jon, for a very candid and informative presentation. There's a lot to learn there for everybody. Thank you very much. If there are questions, perhaps you can just unmute yourself. Elliot Hicks, it looks like you were trying to pose a question in the chat. Perhaps you could just unmute yourself and let us know your question.
No, well, sure. I didn't know I'd have a speaking role in this, but I did ask. We complain all the time about defendants and insurance companies sending sham figures to a mediation who has no real authority. Well, why do we find it acceptable then to have to not have the plaintiff there? I certainly understand during the posturing we have no interest in having the plaintiff there because it does simply build up bad will, bad feelings for them. But if we insist on having an adjuster who has real authority or someone in the client's office who has real authority, why shouldn't we have the plaintiff who has ultimate authority and require them to be there?
Well, again, the plaintiff's attorney should have the authority of their client, number one. And number two is the plaintiff should always be available, especially towards the end of mediation, to agree to it. I mean, a lot of times, some people, when you have a mediation, they want to get a signature right away, right? So yeah, have your client available to sign the settlement agreement right away. But I don't see a reason why a plaintiff needs to sit around for 4 hours most of the time just feeling like they're insulted, and most of the time they're just like not doing anything anyway, and they're just listening. Have your client available, the plaintiff available, to, again, if there is an issue that comes up that you do need the plaintiff there, fine. And second, to say, I agree at the end of the day, that is also a reason. But sitting around all day, I just think generally is a huge mistake.
Okay, Elliot, any follow-up, or does that answer your question?
No, that's fine. Thank you.
And the plaintiff, by the way, the plaintiff's strategy is not, the plaintiff's attorney's strategy also is not going to change if the plaintiff is there.
Well, I've seen it change. I mean, I've seen things go a different way because the plaintiff is there. When they ask that question about whether the plaintiff has actually heard the offer, usually that occurs in the context of a case where the defendant has actually made an offer that most would agree is in pretty good faith. It may not be what the plaintiff's lawyer thinks is enough, but it may be something that tickles the interest of the plaintiff. So, I just thought that it would be important. I've seen divergence. I realize that for the plaintiff's lawyer, that's about the worst thing that could happen. But I've seen changes made because the client was there, because the plaintiff was there.
All right. Well, I don't know. Maybe you're not actually in the plaintiff's room, so maybe it was going to resolve that way anyway. I don't know. But yeah, of course it could happen, I guess. I see a question in the chat box. How do you feel about mediation for coverage issues only before the primary claim is reached? So you're talking about working out any coverage issues. That gets into a whole bunch of different areas. Well, first of all, number one, that just brings up another huge point. If there's multiple defendants on the case, for everybody there, make sure, as a plaintiff's attorney, make sure that those conversations are happening with the defense attorneys and the defense insurance adjusters before mediation. Plaintiff's attorney, you don't want to go to mediation and just sit there and have the mediation be between the defendants, and then nothing happens. So always ask defense attorneys to ask their adjusters to speak to the other adjuster well before mediation, and hopefully at the end of the day at the mediation you're talking about global numbers instead of like a little bit from here, a little bit from there. It just makes mediation, it creates issues at mediation that you don't want to have. But in terms of like working out a coverage issue, meaning like ultimately is there coverage or not? I mean, this question's a little bit vague. I am a huge proponent of working those types of issues out. So if you can agree to like a binding mediation or a binding arbitration, whether coverage applies or whether it's an open policy even, sometimes that's not a bad idea. Going to a binding mediation to agree whether coverage applies or not, and then the mediator ultimately makes the call or the arbitrator makes the call. If you can find a mediator / arbitrator that's willing to do that, then maybe that's a good idea that kind of totally gets rid of an issue on the case. I've done that before, but it needs to be binding. There's no point of going to mediation about a key issue like whether there's coverage or not, and then it's just a long discussion and then nothing happens. So you need to decide whether you want to make that ruling binding or not, and then enter into an agreement about that. So that really opens the door into a whole bunch of different conversations. I hope that answered that question. It was a little bit over broad, so happy to talk about that also if anybody else has questions about that. Pros and cons on brackets. That's the question in the chat. Generally, I'm not a huge fan of brackets. Again, when you're in a full day mediation, maybe in a half day mediation when there's limited amount of time, not a huge fan. I do think that there are pros to it. If you know what you're doing, it's really all a psychological game. I think at the end of the day, again, it's like, I'm really, again, big proponent of looking at middle numbers. So I'm always looking at the middle number in one bracket compared to the middle number in another bracket, and then the middle number of both of those brackets. combined to find that middle number. There's a lot of psychology there. At the end of the day, some mediators love brackets, some don't. I'm a huge proponent of keeping your mediator happy. So if the mediator wants to do it, then do it, because you want your mediator working with you and for you, not against you. So don't, again, these things go out without saying, but I guess there's a lot of people here. Don't piss off your mediator. Your mediator is there to help you. Like, be friends with your mediator. If your mediator suggests something, there's probably a reason why they're suggesting it. I would say 9 out of 10 times I go with my mediator's suggestion, at least for like the first couple of moves, because like, why not? It's not going to hurt you at the end of the day to do that. You know, again, keeping your middle number in mind. If it's something like really extreme that it's really, really going to hurt you, then maybe not. But you can let your mediator guide you, because they know what the other side is thinking, and usually they at least, you know, psychologically have thoughts as to what they're thinking. So help your mediator help you. I don't know why people, you know, don't listen to their mediators. That's just doesn't make sense to me. When you have follow-up discussions with mediator, if you do not settle at mediation, you do end up settling. Does mediator then handle the post-mediation settlement terms in writing? I would hope that, you know, plaintiff's counsel and defense counsel can do that on their own. Again, in California, 99% of the time, the settlement release agreement is pretty standard. And it's mostly just a copy and paste. So I don't see why you need the mediator to write up the settlement for you. I rarely see that. Sometimes mediators have like this quick, like 1-page blurb, like case settled. There's the, I think it's like 664 or whatever that section is, that says like this is enforceable ultimately, and then you have people sign, so you can use that little blurb, and then it usually says, you know, defense counsel and plaintiff's counsel will follow up with the full general release. But at the end of the day, good attorneys can work together and create a pretty standard release agreement. Don't know why you would need your mediator to write the settlement agreement up for you.
Yes,
Again, funky.
let me just echo the wisdom of that. Mediators are not supposed to practice law, and drafting contracts that affect the legal rights of other people is generally considered law practice. So in order to steer clear of practicing law, I believe it's best practice for mediators not to touch the keyboard, not to hold the pen, but to leave to the lawyers who are responsible for protecting their clients' rights, the job of protecting their clients' rights through the written terms and conditions of the written settlement agreement.
Yeah, there you go. Another key thing, whatever, I won't get into that. Just if you're ever mediating against a government entity, be aware that they have all these processes that they need to go get claims authority and whatnot. If you're not very key on that language, know it and make sure that there's language in there in terms of your settlement agreement as to when you're going to get paid, or at least when they're going to bring it to the claims board. I've heard some really bad stories about settlement agreements, and there's no reference in the settlement agreement about how much time there is until they pay you, or how much time it is till they go to the claims board. And then, you know, plaintiff's counsel is waiting forever for a settlement check, and then it never comes. So I'm a huge advocate of making sure that, you know, settlement checks are delivered within 30 days or something like that. Just throw that in the settlement agreement. In the example of a defense opening offer at 15K with a plaintiff starting offer at 1 million, what are some technique strategies to convince defendants to make a big jump towards a more reasonable offer? Again, defense and insurance companies are usually trying to just feel you out at the beginning of mediation. So ignore that silly $15,000 offer. Just ignore it. Just be like, all right, they're going to 15, fine, I'm going to 985. Or, you know, they're going to 15, fine, I'm going to 950. Like, who cares about the first 3 moves? Get them. Eventually they will get to reasonable numbers. So don't, you know, start having a temper tantrum over those first couple numbers. I really just
Jon,
like more than.
isn't the key to getting the defense into a reasonable number for the plaintiff side as well, to get out of the clouds and get into a reasonable range?
Yeah, of course. Of course, the plaintiff needs to get to a reasonable range, and hopefully most plaintiff's attorneys know what that reasonable range is before mediation. And sometimes, yeah, defense attorneys want to set up a mediation just so that the mediator can teach the plaintiff that. Hopefully nobody's doing that to me. I usually know how to evaluate a case, but yes, the plaintiffs shouldn't be out in the clouds. But if you truly believe in your case and you believe the value in the case and you want to go to trial, then maybe there's a reason to be in the clouds. I mean, again, the clouds can be very different for different types of cases. So the clouds on one case can be like 8 figures, $10 million, and the clouds on another case could be $1 million when the case ultimately settles for like, 50,000. So everybody's definition of clouds obviously depends on the case. But again, I would say to both to the defense side and the mediators, you can ignore plaintiff's first 3 moves also. Like, don't allow the first 3 moves to get you all upset and be like, oh, that's it, this case is not settling. So I wouldn't worry too much about the clouds issue. At the end of the day, going into mediation, if your number is $1 million and the insurance company thinks that that's the clouds, guess what? The insurance company's number starts off generally as 0. So that's also the clouds on the other side. So I know some mediators or even the defense are like always focusing, oh, the plaintiff's number's in the clouds. Well, 0 is also in the clouds. So I would not focus too much on that. At the end of the day, it's really generally about that like last hour when mediation gets a little bit more serious, where the numbers start getting serious and you really can feel of like, hey, does everybody really want to settle this case, or no, this case is just not going to settle. And, again, there are reasons why cases are going to settle or not. But yes, generally plaintiff's attorneys don't be in the clouds the whole time. All right. After 3 moves, if you want your case to settle, it's time to, bring the case down to earth and get to real numbers. But again, from the plaintiff's perspective, our job is to get the highest number out there. And we don't generally know what the settlement authority is. It's not our job to let the insurance company save money. So the mediator might think that, the insurance company has $150,000 on a case. Well, it's our job at the end of the day to test that and see, well, maybe they actually had 180 in authority, or maybe they had $200,000 in authority. So, every case is different, but general rule, plaintiff's counsel should be waiting it out and basically waiting till the insurance company says, all right, well, this is it, or we're walking. And then I still then ask them, hey, go call your manager and get me the mediation cost also.
Okay, Jon, thank you very much.
And don't be afraid of mediators' proposals. Mediators' proposals are great. And mediators out there, don't be afraid to make proposals. That's a whole separate conversation, but I love mediators' proposals. I think mediators should highly suggest doing them. I know there's sometimes you get like, oh, we don't want a mediator's proposal. Be a great mediator and believe in your ability to settle a case and say, you know what, I think I should do a mediator's proposal, and hopefully convince everybody to do it. I think it's really helpful.
Okay, Jon, that was wonderful. Thank you so much. I'm confident that Jewish Family Services of Los Angeles will receive a lot of contributions, will help to feed a lot of hungry people as a result of this presentation, and that's what it's all about. Thank you very much. With that, we are complete.
All right. Thank you so much, everybody. Again, feel free to call me or email me if you have any further questions. I really appreciate the opportunity, and nice to meet all of you.
Thank you.
Thanks.